Good afternoon, ladies and gentlemen. The Chairman, Board of Trustees, the founder, YouthRISE Nigeria, permit me to stand on the protocol that's already been established. My name is Tem Mbuh. I'm from Cameroon, but I feel so much at home in Nigeria that each time I come here and go around for meetings, I parade myself as a man from Akwa Ibom, and a lot of people believe me. Yeah. So, I bring you greetings from the Open Society Foundations, our Executive Director, Mutoni Wanyeki, who would really have loved to be here, was unfortunately indisposed, but she sends her very warm greetings and her congratulations for the celebration of the 10th anniversary of YouthRISE Nigeria. I want to really heartily congratulate the leadership, the staff, and all well-wishers of YouthRISE Nigeria for this 10th anniversary. From very, very humble beginnings, YouthRISE has today morphed into a leading national institution that is at the forefront of policy reform for equity and justice for the most vulnerable. We at the Open Society Foundations, and Osiwa in particular, are extremely honored and gratified to have taken a chance on YouthRISE when it was at its very infancy. We are proud, and very proud for that matter, that our early support has paid off, and we are here today celebrating a decade of the momentous achievements that we've just seen. Now, I was asked to share my perspectives on a matter relating to young people and how equity and justice are central to their development. Now, I took the liberty to frame my remarks on the topic, the weaponization of criminal law against poor and vulnerable young people. Now, I chose this topic to draw attention to the thousands of invisible young people who are locked away in prisons and detention facilities, and who in many cases do not deserve to be there. Incarceration has become pervasive, and it has very significant negative effects on young people and their development prospects. Again, conversations about young people in detention facilities do not make it into mainstream discussions, and even though it is a very unpopular topic, I think we need to speak about this injustice. Now, over the past years, I've had the opportunity as part of my work with Open Society Foundations to support a lot of legal aid organizations across Africa. And I'm always quite interested and intrigued by the stories of mostly young people who benefit from this legal assistance. And none of these stories has quite touched me like that of Toure, a young Sierra Leonean who was arrested by the police in 2010 in Freetown. He was just 18, and he was arrested for the crime of loitering under a public policy, 1965 Public Policy Act. He had reportedly not been able to give a good account of himself and was therefore deemed to be an idle and disorderly person. Following his arrest, he was sent to the Freetown Central Prison, where he spent 7 years in pre-trial detention. Not once during those 7 years was he brought before a judge. Being poor, he could not also afford the services of a lawyer and was essentially swallowed up in the belly of a system he had no understanding of. It was only in 2017 that paralegals from one of our partner organizations called Tem Mbuh for Justice came to his aid. His file had been lost, and no one in the justice system could explain why he had been imprisoned in the first place. But with the help of Tem Mbuh lawyers, Toure was released. Now, what is most sad about Toure's situation is that had he been tried by a court of competent jurisdiction, his maximum sentence would have been 1 month or a fine. A young life full of dreams and potential was destroyed by a justice system that failed to afford him due process. Now, there are numerous Toures in prisons across the world and in Nigeria today, where criminal law, procedure, and policing continue to reflect a brutal colonial legacy. Law enforcement, courts, and prisons are routinely deployed against the poor and marginalized for reasons that have very, very little to do with safety, but rather to protect the boundaries of wealth and privilege. The application of this power manifests in fundamental human rights violations, and we heard what the community members were saying here. It manifests in excessive imprisonment, it manifests in disproportionate sentencing and inhumane detention conditions. Now take the case of drug law offenses, for example, in Nigeria. Unlike other countries, the laws on drug-related offenses in Nigeria do not provide for acquisition, use, or possession of drugs for personal use. The National Drug Law Enforcement Agency Act, Chapter 30, Laws of the Federation of Nigeria, 2014, Section 19, prescribes punishment for drug-related offenses ranging from 15 to 25 years imprisonment. It doesn't distinguish between major and minor drug-related offenses, and the sentencing regime is clearly harsh, it's unjust, it's inequitable. In addition to this, there is a raft of colonial-era petty offenses laws which have no place in today's legal arsenal, but which are overzealously policed, and disproportionately, these offenses affect very poor and vulnerable categories. Name them: hawkers, commercial bike riders, sex workers, persons with disabilities, informal traders, and persons who use drugs. We heard the cases of the community members saying how police arrest them and harass them. What is common among this category of persons is that they are mostly poor, and for the most part, they are also young. This injustice is made worse by a criminal justice system that is dysfunctional and not fit for purpose. According to the most recent statistics from the Nigeria Correctional Services, over 70% of the 73,806 inmates in Nigerian prisons are awaiting trial. 70% are awaiting trial. And despite the fact that the Administration of Criminal Justice Act 2015 provides for alternatives to detention, this is hardly ever applied. For evidence, as of July 2022, alternative sentences were in effect in only 268 cases in Nigeria. We had 166 cases, people on community service, just 3 on parole, 7 on probation, 18 serving various restorative justice measures, and 74 classified as other measures. Now, this indiscriminate use of incarceration as a form of punishment has led to waste many young and productive lives. Even when released, often with no prospect of employment, these young people are generally subject to socioeconomic exclusion and are thus vulnerable to an endless cycle of poverty, marginalization, criminality, and imprisonment. Imprisonment therefore contributes directly to the impoverishment of these young people, their families, and society by creating future victims and reducing future economic potential and performance. Criminalization is a driver of marginalization. It is traumatic and it creates risks. It disproportionately harms people already surviving multiple forms of oppression, notably economic deprivation. This punitive response as well also siphons resources from what communities really need and rightfully deserve. Access to education, access to affordable healthcare, nourishing food, stable housing, sustainable livelihoods, and caring and nurturing environments. Now, Professor Noble Morris, one of the most respected global prison reform advocates in his book, The Future of Imprisonment, has posited that prison is, after all, the largest power that the state exercises in practice on a regular basis over its citizens. Perhaps, if we could bring principle and justice to the exercise of power, of imprisonment, much else will improve in the uneasy tension between freedom and authority in post-industrial society. The overreach of the criminal justice system has made hypocrites of us all and has cluttered the courts and filled the jails and prisons and detention facilities and reformatories with people who do not deserve to be there. Now, undoubtedly, as human beings, we all aspire to live in healthy, safe, and free communities. But many studies have shown that there is no causal link that has been established between the use of detention and greater public safety. There are many options available for dealing with issues that threaten the vision of a safe, secure, and healthy society, which can be achieved without resorting to disproportionate incarceration. First, I suggest that we need to radically reimagine the criminal justice system. We need to reimagine its purpose, its processes, its outcomes, and properly interrogate all of this to make sure that the objectives of law, order, and safety are attained in a just, equitable, and humane manner. This will entail reviewing several laws and revisiting sentencing policy, and in seeking to impose what is a just and fair punishment for any kind of malfeasance. The mantra that punishment must fit the crime needs to be seriously considered. And in that regard, I believe Nigeria could borrow a leaf from Ghana, which recently revised its Narcotics Control Commission Act. The new act seeks to treat drug use and dependence as a public health issue rather than focusing on law enforcement, punishment, incarceration, and repression. The law has converted the prison term for drug possession for personal use, for instance, into a fine of between 200 and 500 penalty points, which translates into approximately a maximum fine of 600 USD. This means that instead of sending people to prison for up to 10 years in Ghana for simple possession, as was the case prior to 2020, these people are now simply required to pay a fine, and they are treated as patients who need help. This is the way a state shows compassion to its citizens. This is the human rights approach to drug use that we encourage states to adopt. This is the kind of centering of dignity of the human person that we are advocating for. The Ghanaian example also highlights the need to actualize some of the alternatives to incarceration already provided for in Nigerian law, notably the Administration of Criminal Justice Act and the Correctional Services Act 2019. Secondly, all colonial era vacancy laws, vagrancy laws, need to be decriminalized and expunged from the Nigerian Penal Code. It is such a shame, and it's just not in Nigeria, it's across Africa. It's such a shame that a lot of the laws that colonialists used to control us as a conquered people are still in use today, but they are just used against a certain category of people who are mostly poor. A lot of these laws afford arresting authorities outsized discretionary powers which are abused and arbitrarily applied. And in that regard, the African Commission on Human and People's Rights has adopted guidelines on the declassification and decriminalization of petty offenses in Africa, which can serve as a useful guide to the Nigerian authorities. The African Court on Human and People's Rights in 2020 also issued an advisory opinion holding that the continuous enforcement of vagrancy laws are inconsistent with provisions of the African Charter on Human and People's Rights, and in that opinion, it urged various state parties to the Charter to decriminalize these offenses. Nigeria has ratified the African Charter on Human and People's Rights, and it has even gone ahead to domesticate it in its constitution, in its Chapter 2. Now, these are just suggested short-term fixes, but if carceral policy is to be grounded in fairness, justice, and equity, there will be a need for a deeper reflection on the place of the criminal justice system in keeping our communities safe while respecting fundamental human rights of all persons who come into contact with the system, the majority, unfortunately, being poor and young persons. I thank you.